There is a room in King County, Washington, that in the summer of 1974 had become almost entirely organized around paper. Not the ordinary paper of a working office, the memos and budget reports and correspondence that accumulate in any institutional space, but something denser than that, and more particular: tip sheets, telephone message slips, handwritten notes taken by officers at the other end of calls from members of the public who had seen something, heard something, or simply felt, with whatever degree of certainty, that a name they knew might belong to the case. The sheets arrived by mail. They arrived when officers transcribed calls. They arrived when detectives came back from the field and wrote up what a witness had told them over a kitchen table or across the hood of a car in a parking lot. They accumulated in stacks, and the stacks were sorted into folders, and the folders were assigned to categories, and the categories were themselves still being refined as summer moved forward, because the task force was new, and the system for managing what it was receiving had not yet settled into a final shape. This was the physical reality of the investigation in its early months. Not a computer database, not a centralized digital system, cross-referencing names and dates and locations across multiple agencies. A room with tables and files and a telephone that rang with some regularity, and detectives working through what came in as methodically as the volume would allow. The task force had been formally established that summer after a pattern of disappearances in the Seattle and Tacoma areas had become too concentrated, too compressed in time for any single agency to manage alone. King County detectives, investigators from the Seattle Police Department, and personnel from the King County Sheriff's Office had been brought together under a coordinating structure whose purpose was to share information and work the cases collectively, rather than in the overlapping, occasionally redundant, way that multi-jurisdictional investigations had a tendency to proceed. The disappearances had been occurring with a regularity that made random circumstance a less and less satisfying explanation. Young women, college age, many of them, gone from parks, from campuses, from ordinary public places in the middle of ordinary days, with no confirmed trace afterward, no witnesses who could say definitively what had happened, and no physical evidence recovered at the locations from which they had vanished. The task force gathered because the pattern was there, even if its precise shape was still being mapped. Establishing a shared investigative structure was the straightforward part. What came harder was the information itself, the sheer quantity of it, and the challenge of determining, within any given week, which pieces of it were worth pursuing. Tips about missing persons cases of this kind tended to generate significant public response. When composite sketches appeared in newspapers and on television, the phones began to ring. When names were solicited through public appeals, people called with names. The challenge was not a shortage of information. The challenge was the opposite condition, an abundance of incoming material that had to be assessed and sorted and followed up on by a team of investigators working within the ordinary constraints of available hours and available personnel. Detective Robert Keppel of the King County Sheriff's Office had taken on the particular work of organizing the tip intake system. The job was, in its essential nature, a problem of scale and method. How to ensure that a name submitted once did not get lost simply because it had been submitted once. How to connect a detail in one folder to a detail in another folder that had arrived weeks earlier by a different route. How to maintain enough order in the accumulation that any individual tip could be located and reviewed again if something later made it relevant in a new way. Keppel worked through this largely by hand, as the task force's resources and the technology of the era required. index cards, manila folders, long tables covered with materials organized by date of submission, by the nature of the tip, by the name offered, by cross-references that had to be maintained manually if they were to be maintained at all. The tip sheets kept arriving. Kepil's system kept receiving them. Among the focal events that had generated the heaviest response from the public was what had occurred at Lake Semi State Park on a warm Sunday afternoon in July 1974. The park was east of Seattle, a popular summer destination picnic areas, a public beach, open ground where families spread blankets and groups gathered in the ordinary way of a weekend in good weather. On that particular afternoon, two young women vanished from the park independently of one another. Janice Ott and Denise Nausland had each been at the park that day, separately, among the crowd. Neither returned. Their disappearances became two of the central cases the task force was working, and what distinguished them from some of the other cases on the growing list was the presence, at Lake Sammamish that afternoon, of witnesses. Multiple witnesses, independently of one another, reported a man at the park who had approached young women with a request. He wore his arm in a sling. He introduced himself as Ted. He explained to each woman he approached that he was having trouble with his sailboat and needed help. Some of the women who were approached declined and left. At least two did not. The witnesses who later spoke with investigators described the man in terms consistent enough with one another that a composite sketch was developed. A young man, conventionally attractive, the sling visible on one arm. The sketch was reproduced in Pacific Northwest newspapers. It appeared on community notice boards. It was seen, as such sketches were, by people who looked at it with varying degrees of recognition. Among the people who saw that sketch was a woman named Elizabeth Klupfer. She was in a relationship at that time with a man named Ted Bundy. What Klopfer saw in the composite sketch concerned her enough that she called the task force tip line, the account she gave investigators at that time, the name she submitted, the observations she offered about the person she knew was logged in the system. Her concern did not stop with a single call. She contacted the tip line more than once, returning to her unease, offering the same name through the same channel. The information documented each time it came in. The tip sheet bearing Ted Bundy's name was filed in Keppel's system alongside the thousands of other tips that had arrived through that summer and into the fall. It was assigned to a folder. The folder was part of a sequence. The sequence was part of a room. The nature of what the task force was building, its index cards, its cross-references, its hand-sorted categories, was a structure designed to hold and organize information for the moment when a particular combination of facts became actionable. The system was not passive. Investigators were pursuing leads, conducting interviews, following up on tips that seemed promising by whatever measure the available evidence suggested. But the volume of material was significant, and the resources available to work through it were finite, and certain pieces of information moved toward the active end of the queue faster than others, for reasons that were sometimes apparent and sometimes simply a function of the order in which things arrived, or the other cases pressing for attention on a given week. What made the work harder still was a structural condition that had nothing to do with the task force itself, and everything to do with the architecture of law enforcement in the United States at that time. The crimes being investigated in King County were King County crimes. They were the business of the agencies gathered in that room with its stacked folders and ringing telephone. Cases occurring across the state line in Oregon were the business of Oregon investigators. Cases in Utah were Utah matters. Cases in Colorado were Colorado cases. Each jurisdiction maintained its own files, ran its own investigations, and had its own lines of inquiry to follow. There was no standardized protocol that required one state's investigators to routinely share case files with another's. No operational system for the regular cross-referencing of disappearances that had occurred in different states. No centralized national repository for the pattern data that could in principle connect what was happening in the Pacific Northwest to what might be occurring elsewhere. The FBI's VICAP system, the Violent Criminal Apprehension Program, the national database designed specifically to address this kind of jurisdictional isolation, did not yet exist in operational form in 1974. It was, in that year, a concept being discussed among law enforcement professionals. The problem it was intended to solve was well understood by detectives working the cases of the era. The solution had not yet been built, and in the absence of that infrastructure, individual agencies maintained what they maintained, knew what their own files showed them, and had no efficient mechanism for discovering that investigators 2 states away were looking at something that shared characteristics with their own open cases. A map of the western United States, with its state lines and county boundaries, represents the investigative reality of that period in something close to its full complexity. Each county had its own sheriff. Each state had its own law enforcement structure and its own procedures for how cases were classified, filed, and pursued. A disappearance in one county was visible, in a formal sense, only to the agencies within that county's jurisdiction, unless someone took specific steps to share the information across the line. Those steps were taken sometimes. Investigators did call one another. Detectives did, on occasion, travel to compare notes with their counterparts in neighboring jurisdictions. But the connections were informal, dependent on individual initiative, and not guaranteed by any system that would have made them automatic. This meant that in the summer and fall of 1974, as the King County Task Force worked through its tip sheets and cross-referenced its index cards, the disappearances occurring in other states remained separate matters, being tracked by separate people. The pattern that was visible within King County's records was not visible to anyone looking at the larger picture, because no one had yet assembled the larger picture in any place where it could be systematically read. The task force continued its work. Tips continued to arrive. Keppel continued to organize what came in. It is worth dwelling for a moment on the physical nature of that process, not because it was unusual for its time. It was, in fact, entirely standard for its time, but because the gap between what the system was designed to do and what it was structurally capable of doing was itself a significant feature of this period in the investigation. A tip sheet for a name like Ted Bundy's, submitted once and then again by the same caller, was a piece of paper in a folder. Its value to the investigation depended on several things: whether it was retrieved for active follow-up, and whether the information on it was sufficient to move it into the queue of tips being actively worked, whether the investigator who reviewed it had access to whatever other information might have given it additional weight, and whether, in the steady flow of incoming material, it remained findable and present in a way that allowed it to be returned to. The system was not designed to lose things, it was designed to hold them. But holding and acting on are not the same thing, and a file system of that scale, maintained manually, under the pressure of a high-volume investigation with limited personnel, could not guarantee that every piece of information received the same degree of active scrutiny at the same time. What the tip intake records show for that summer and into fall is that Bundy's name appeared in the system on multiple occasions. Different individuals had submitted it through different routes. Elizabeth Klupfer's calls were part of that pattern. Others, separately, had arrived at the same name and offered it through the same channel. The information was present. It was in the folders. It was part of the accumulation that Keppel's system was designed to manage. The summer of 1974 moved toward its close, and the folder in which that name was stored moved no closer to the front of any active queue. The cases on the active inquiry list were pursued by available investigators following available leads. The tip system continued to receive and organize and file. The room in King County continued its quiet, paper-intensive work. There is a particular quality to the Lake Sammamish witness accounts that the case file records in some detail. The park had been crowded that day, one of those July Sundays in the Pacific Northwest, when the weather is warm enough to draw people out in significant numbers to a place with open water and shade and space to spread across. The witnesses who had seen the man calling himself Ted had not been, for the most part, on high alert for anything. They were at the park on a Sunday. They had been approached by someone asking for help. The sling on his arm, the way he introduced himself, the sailboat story, these were details that had registered because the encounter had been slightly odd, or because they had later heard about the disappearances and thought back to what they had seen, or simply because the composite sketch in the newspaper had matched a face they had briefly known. The consistency of what those witnesses described was notable, not identical. Witnesses rarely describe the same event identically, and the case file does not present these accounts as though they were, but overlapping in the ways that independent witnesses sometimes overlap when they have seen the same person in the same place doing the same thing. The sling appeared in multiple accounts. The name Ted appeared in multiple accounts. The sailboat appeared in multiple accounts. The investigators who gathered these statements had enough consistency across them to develop the composite sketch and to use the name Ted publicly, which was itself an unusual investigative decision to make public a first name drawn from witness accounts before a full suspect had been identified. The sketch appeared in the newspapers, and the phones rang, and the tip sheets accumulated, and among them was Elizabeth Klepfer's call, and then her second call, and then the names submitted by others who had also looked at the composite and thought of someone they knew. Detective Keppel's tables held it all. One of the structural challenges of a tip intake system in an investigation of this scale is that it is, in its nature, democratic in a way that can work against it. Every tip arrives with roughly equal bureaucratic status. A call from someone with a name that will later prove consequential enters the system in the same form as a call from someone whose name will prove to be one of many that lead nowhere. The system does not know, at the moment of intake, which is which. It records, categorizes, cross-references, and holds. The subsequent work, the determination of which tips merit immediate follow-up and which sit in the file, waiting for a later development to make them newly relevant, is a human judgment made under the pressure of time and volume and limited investigative resources. This is not a failure unique to any one investigation or any one jurisdiction. It is a feature of how information was managed in law enforcement investigations during that period, before digital databases allowed for the kind of rapid cross-referencing and pattern analysis that would later become standard. The task force in King County was working with the tools available to it, organizing what it had with as much care and method as the system allowed. That the tools available were limited is a fact about the technological and institutional circumstances of 1974, not a characterization of the effort being made. The effort was considerable. Keppel's work on the tip database was meticulous by the standards of what was then possible. The investigators working the active leads were following them with the resources and time they had. The task force had been established precisely because the conventional jurisdictional boundaries were already insufficient for a pattern of this scale, and the agencies involved had recognized that and responded to it by building a collaborative structure where none had previously existed. And still the folder held its paper, and still the tip sheets sat in their sequence, waiting. There is something in the accumulated record of these early months that is worth noting in its plainest form. By the end of 1974, Ted Bundy's name had been submitted to the King County Task Force by multiple independent sources through documented channels. It was in the system. Elizabeth Klepfer had called more than once. Others had called too. The information that might eventually connect the composite sketch from Lake Samish to a real person with a real address and a real history had been offered, received, logged, and filed. The system did not yet have the capacity to recognize what it had, not for want of effort, not for want of care, for want of the infrastructure, the cross-jurisdictional databases, the national pattern matching systems, the computational tools that the investigations of that era were simply not equipped with. A map of the Pacific Northwest in the summer of 1974 has a particular quality when examined with the knowledge of what was happening there. The geography itself is notable. The deep forests of the Cascade foothills, the parks along the water, the college campuses spread across the region in their ordinary configurations of buildings and paths and public space. These were familiar landscapes. People moved through them daily without particular concern, which was itself a reflection of what was not yet known. The task force knew a pattern existed. The public, to varying degrees, had been alerted to a concern. But the full shape of what the pattern represented was still being assembled, piece by piece, in a room in King County, where the paper kept arriving and the telephone kept ringing and the folders kept filling. The composite sketch pinned to notice boards across the Pacific Northwest showed a young man with an arm in a sling. It appeared in newspapers. It was reproduced alongside public appeals for information. It sat on kitchen tables in Seattle and Tacoma and in the homes of people who looked at it, and some of them recognized something in the face. Among the things the investigative record shows is that human beings are not always certain what to do with recognition. Klepfer called and called again, and her calls were received and logged. She was not the only one. The accumulation of those calls, the names offered, the concerns expressed, the composite sketch matched to a face someone knew, represents a significant volume of incoming information that the system was working to manage while simultaneously working the active investigative leads that required daily attention. The papers in Keppel's folders represented weeks and months of that incoming stream. By the close of 1974 and into 1975, the system held what it had been given. Bundy's name was in it, logged more than once, noted under different submissions, cross-referenced into the broader category of names that had been offered in connection with the composite sketch and the pattern of disappearances. The folder that held it was one of many folders in a room that was still as autumn turned and the case continued, doing the painstaking work that the investigation required. The task force had been built for exactly this kind of work: slow, methodical, attentive to the record, organized around the principle that the information needed to advance the investigation was almost certainly already present somewhere in the accumulated material, waiting for the development that would allow it to be read correctly. That principle was right. The information was there. The name was there, filed in sequence, resting in a folder on a table covered with other folders in a room in King County, in the long quiet of a case that was still finding its shape. The tip sheet bearing Ted Bundy's name, Elizabeth Klepfer's concern, set down in ink, assigned a number, placed in its proper sequence, sat in the system alongside thousands of others. It was present, it was held, it was waiting, as such records wait, for the moment when everything around it would have accumulated enough that the shape of what it described could finally be read in full. That moment had not yet come. The room held its paper, the folders held their tips. The investigation continued, as investigations do, one careful day after another, in the way that cases of this kind are worked. Not quickly, not dramatically, but with the steady, unhurried attention that the record, and the people in it, and the questions still left open, had always deserved. A flashlight beam moving across the interior of a stopped car in the early hours of a morning in August, in a quiet residential neighborhood in Granger, Utah. This is where the documented legal record of Ted Bundy begins to take its visible shape. Sergeant Bob Hayward of the Utah Highway Patrol had pulled behind a tan Volkswagen Beetle after observing it moving without headlights through the neighborhood streets. The hour was late. The streets were otherwise empty. When Hayward approached the vehicle and the driver's side window came down, the exchange that followed was routine in its opening form, a traffic stop like others, conducted on a quiet road in the dark before dawn on August 16, 1975. What the subsequent search of the vehicle produced was a collection of items laid out across the car's interior in the beam of Hayward's flashlight. A crowbar, a pair of handcuffs, a ski mask, a length of rope, an ice pick. These were cataloged and documented, each one noted in the inventory that would become part of the formal record of the stop. The driver identified himself. He provided his name and offered an explanation for each item. The handcuffs, he said, he had found at a theater. The other things had various ordinary explanations. Hayward was not satisfied. The items were seized. The driver was taken in. What followed from that traffic stop over the course of the next several months was a set of legal proceedings that moved carefully through the established steps of the Utah system. The items from the car constituted physical evidence, but physical evidence of that kind requires a corresponding crime to carry legal weight as something more than possession of assorted hardware. The case needed a witness. It needed a direct and specific account from someone who could place the man from the tan Volkswagen inside an event the law could formally address. That account came from Carol Duranch. Duranch had survived an attempted abduction in Murray, Utah, in November of 1974, nearly a year before Hayward's traffic stop. What she had experienced that night was a specific and documented event, an encounter in a shopping mall parking lot with a man who had presented himself as a police officer, who had told her that someone had broken into her car, who had persuaded her to accompany him, and who had then, inside his vehicle, attempted to restrain her with handcuffs before she had escaped. The account she gave to investigators at the time was detailed. Her identification of her attacker, when investigators brought her forward for a formal lineup, was given with a high degree of certainty. She identified the man from the tan Volkswagen Beetle. She identified Ted Bundy. The lineup is a particular kind of documented moment in a case. It stands as a formal procedure, conducted under specific conditions, recorded in formal language, its outcome entered into the file as a named finding. Duranch's identification in that lineup was the evidentiary anchor on which the Utah prosecution built its case. It connected the man with the handcuffs, the crowbar, the rope, and the ski mask to a specific night and a specific act as described by a specific surviving witness who had been present for the event and who was willing to stand in a formal legal setting and say what she saw. The trial proceeded in 1976. The charge was aggravated kidnapping, a serious felony under Utah law. Bundy, at that point, was represented by counsel. The proceedings moved through the documented stages of a criminal case in an American state court: charges, arraignment, pretrial motions, the presentation of evidence, witness testimony, closing arguments, the jury's deliberation. In March of 1976, the jury returned its verdict. Bundy was convicted of aggravated kidnapping. The judge imposed a sentence of 1 to 15 years at Utah State Prison. The courtroom in which that verdict was delivered was, by all documented accounts, an ordinary space. Wooden benches in the gallery, fluorescent lighting in the ceiling, a jury box arranged along one wall, the jurors seated in 2 rows, a witness stand at an angle to the bench, positioned so that the witness could be seen clearly from both the jury box and the gallery. The formality of such a room is its own kind of document. Everything arranged according to a precise logic developed over generations of legal proceeding. The positions of each person in the room mapped against an established understanding of what a trial requires. Bundy took his place in that room as a defendant. In March of 1976, the formal record placed him in the defendant's position and recorded the result of the proceeding against him. Utah State Prison received him in March of 1976. The incarceration that followed was the first time Bundy had been held in a correctional facility in connection with a criminal conviction. The institution was what it was: a state prison in the Mountain West, operating under the administrative conditions of a mid-70s corrections system. Bundy was assigned to a cell. He was given a number in the institutional register. He was subject to the rules and routines that governed the facility. His days took on the shape that imprisonment imposes. The legal record did not stand still while he was held there. Other jurisdictions had been developing their own cases. Colorado, in particular, had been building a file connected to the disappearance of a woman named Karen Campbell from the Wildwood Inn near Snowmass Village in January of 1975. Campbell had been at the inn with her fiancé and his children. She had left the group in the elevator lobby to return briefly to their room for a magazine and had not come back. What investigators in Colorado had assembled through the months and years of their investigation was a case that was formally connected to Bundy after his Utah arrest. Extradition proceedings were initiated. In January of 1977, Bundy was transferred from Utah State Prison to Colorado. The extradition placed him under the jurisdiction of the Colorado courts, specifically the Pitkin County court system, which was handling the Campbell case. The facility that received him was the Garfield County Jail in Glenwood Springs, a relatively modest structure, not a maximum security prison, set within the mountain terrain of western Colorado. The building's physical scale was distinctly different from a high-security institution. Its setting was surrounded by the particular landscape of the Rocky Mountain West: elevation, pine forest, the kind of terrain that is beautiful, and also at certain seasons and in certain conditions, unforgiving to move through without proper preparation. The Garfield County Jail was where Bundy would be held during the pretrial period as the Colorado proceedings moved forward. This arrangement, holding a defendant in a county jail rather than a state prison during the extended pretrial phase of a major criminal case, was not unusual. County jails serve this function routinely in the American system. They house people awaiting trial, people serving short sentences, people in transit between other facilities. The Garfield County facility was fulfilling a standard institutional function in holding Bundy while the Pitkin County court system worked through the preliminary stages of his case. The courtroom in Aspen, in the Pitkin County Courthouse, was where the legal proceedings were formally centered. Aspen itself is a small mountain town, its character shaped by the altitude and the landscape as much as by the seasonal rhythms of a place that draws visitors and residents from elsewhere. The courthouse stood in the town's center, a building of the kind that small American counties have built for their civic functions, scaled to the needs of a county government and court system, serving a relatively small permanent population. The building had multiple floors. The law library was on the second floor. Bundy, at this stage of the proceedings, made the decision to represent himself, to proceed as what the legal system designates a pro se defendant. This is a right recognized under the American legal framework. A defendant who meets the legal standard for competence, who formally waives the right to counsel and accepts the responsibilities that come with that waiver, is permitted to conduct his own defense. The court system then makes certain accommodations for a pro se defendant that would not be extended to someone represented by an attorney, not because the rules are suspended, but because a defendant conducting his own defense has a genuine need for direct access to legal materials and proceedings in order to exercise the right in any meaningful way. For Bundy, one practical consequence of his pro se status was access to the Pitkin County Courthouse Law Library. This is the mechanism through which that access was granted. A defendant preparing his own defense requires the ability to conduct legal research, to review statutes and case precedents, to draft filings, and examine the legal landscape of the proceedings against him. The law library in the courthouse provided the resources for that work. Bundy was transported from the Garfield County Jail in Glenwood Springs to the Aspen Courthouse for pretrial hearings and for law library research sessions. The distance between Glenwood Springs and Aspen is approximately 40 miles along mountain roads. The transport arrangements were managed by the Sheriff's Department. The law library on the second floor of the Pitkin County Courthouse was a working legal research space, the kind of room that exists in courthouses across the country, furnished for its function rather than its appearance. Shelves of legal volumes ran along the walls, case reporters, statutory compilations, legal encyclopedias, the accumulated printed material of American law in the mid-1970s, before digital databases changed the practice of legal research entirely. A long table occupied the central space. The surface of the table held whatever documents the researcher was working with on a given day. In Bundy's case, the papers pertaining to his own proceedings in the Pitkin County court system, the motions and briefs and legal arguments that constituted the material of his self-represented defense. The room also had windows. On the second floor of a courthouse building, a window looks down onto whatever surface lies at that level's distance below: a street, a sidewalk, the grounds adjacent to the building. The specific geometry of that drop, from sill to ground, is a physical fact of the room's construction. It is the kind of detail that belongs to the building's architectural record, rather than to any case file present in the structure, neither notable nor concealed, simply part of what the room is. Bundy was brought to that room on a series of occasions during the pretrial period. He sat at the long table with his papers. He worked through the legal volumes on the shelves. He filed motions with the court. He made arguments in the hearing room downstairs. The research sessions in the law library were a documented part of the pretrial process, authorized, arranged through the formal transport and supervision system that governed his movements between the jail and the courthouse. The hours he spent in that room were hours spent, in the formal terms of the legal arrangement, preparing his own defense. The supervision that accompanied those sessions was the responsibility of the personnel assigned to escort and monitor him during courthouse visits. What the post-event record later established was that the supervision arrangements during the law library sessions were not what the security classification of a defendant facing a murder charge in Colorado would, in retrospect, require. The details of those gaps, what was covered and what was not, when the room was observed and when it was not, are part of what the subsequent internal review addressed. That review came later. The sessions in the library continued as arranged while the pretrial proceedings moved through their scheduled stages. The Garfield County Jail, for its part, was holding Bundy in conditions appropriate to a county detention facility of its era and size. The facility was not a maximum security prison. Its construction and its staffing reflected the operational scale of a county jail serving a jurisdiction whose ordinary population did not routinely include defendants facing major felony charges with the classification Bundy carried. The jail processed him as a resident during the pretrial period, managing his transport to Aspen when court appearances and research sessions were scheduled, receiving him back in the evenings. The institutional rhythm of that arrangement, the transportation, the check-ins, the room where he slept, the meals delivered on schedule, was the rhythm of a county facility doing what county facilities do. The legal proceedings in the Pitkin County system during the first months of 1977 were moving through the preparatory stages of what would eventually become a trial. Motions were filed and argued, scheduling was established and adjusted. The particular administrative complexity of a case involving a defendant who was both his own counsel and a prisoner requiring transport between two different mountain towns added logistical dimensions that the court system and the sheriff's department were managing as the proceedings developed. The record of those months is a record of a legal process working through its established steps, each document filed, each appearance made, each motion decided, each date set down in the court calendar. Bundy was present for those proceedings in the way that defendants are present, physically in the courtroom when appearances required it, physically in the law library when research sessions were scheduled, physically in his cell in Glenwood Springs when neither was underway. His movement between those three locations, the cell, the courthouse hearing room, the courthouse law library, defined the physical geography of his existence during those months. Each location had its own character, its own set of physical constraints, its own set of documented features that belonged to the record of where he was held and how he moved. The Pitkin County Courthouse Law Library, across those months of pretrial preparation, became a place Bundy knew with some intimacy. Not in any way the court proceedings formally noted or the supervision arrangements formally accommodated, but in the practical sense that a person who spends extended hours in a room comes to know it, where the shelves run, where the table sits in relation to the door, where the light falls during different parts of the day, and where the windows are placed in the walls, and what can be seen from them, and what lies below. The long table in that room, with its papers and legal volumes, and the notes of a pro se defendant preparing arguments for a murder charge, sat at a particular distance from the window beside it. That window, looking down from the second floor onto the ground below, was a feature of the room in the same way that the table and the shelves were features of the room, present, physical, part of the building's construction. The pretrial sessions continued. The motions were filed. The calendar moved forward toward a trial date. What the formal arrangement had produced over the course of those months was a defendant who was well acquainted with the internal layout of the building in which his case was being heard. The law library on the second floor, the stairwells and corridors between the library and the courtroom, the exits from the building at various levels. the relationship between the inside of the building and the street and grounds outside it. These were features of the physical environment that anyone who moved through the courthouse regularly for extended periods across multiple visits would come to know through simple familiarity, the way that any repeated journey through the same space leaves a detailed impression of what that space contains. The supervision during those law library sessions, as the subsequent internal review would document, had gaps. The windows in the law library had not been assessed or modified in light of the security classification of the defendant who was using the room. These are the documented findings of the post-event review process, part of the institutional record of what the Pitkin County system examined after the fact and what it concluded. That review belongs to a later part of the chronology. The sessions in the library during the spring of 1977 continued under the arrangements as they existed. There is a particular quality to the documentary record of this period. The months between Bundy's arrival in Colorado in January of 1977 and the events of early June, the papers accumulated in the court file. The hearings proceeded. The scheduled dates were met. The transport van made its trips along the mountain road between Glenwood Springs and Aspen, returning each time with its passenger, checking him back in at the jail, closing the record of another day's courthouse activities in the formal log. The record of those months, read in sequence, is a record of an ordinary pretrial process moving through its expected stages, routine in its paperwork, routine in its scheduling, routine in the back and forth of motions and responses, and calendar management that defines the pretrial period in any serious felony case. The second-floor law library sat quietly in the courthouse building through those months. The window beside the long table looked down at the ground below. The legal volumes stood on their shelves. The papers on the table held the arguments of a defendant preparing to conduct his own defense against a murder charge in a Colorado mountain town. The room was what it was: a working space, a research space, a space made available to a pro se defendant through the formal provisions of the legal system that was also working to prosecute him. The arrangement carries within it a particular kind of institutional logic that is visible most clearly in retrospect. A defendant has the right to conduct his own defense. A defendant conducting his own defense requires access to legal resources. Legal resources are located in the courthouse. The courthouse has law libraries. The law library has a table and shelves and a window. The window is on the second floor. These are the sequential facts of a system operating according to its own rules, each step following from the one before it, according to principles that are individually reasonable and collectively produce a specific outcome. The internal review, when it came, documented those steps in the formal language of institutional self-examination. The pretrial period in the Pitkin County system was where Bundy spent the spring of 1977. The court calendar moved. The motions were filed and decided. The research sessions in the law library continued on their scheduled basis, each one logged in the transport records and the courthouse visitor documentation. The table in the library held his papers. The window held its place in the wall. The drop to the ground below was what it was, a physical feature of the building, present and unremarked, belonging to the architecture of a courthouse that had been designed for the conduct of legal proceedings rather than for the containment of a defendant of Bundy's particular classification. What the record of those months does not contain is any documented notation from the supervision arrangements of the library sessions that indicates the windows were examined, assessed, or modified. The oversight was institutional rather than individual, a gap in the framework that governed how the space was configured for a high-risk defendant, not a specific failure that can be attributed to a single person on a single day. The internal review would note this. The review's conclusions are part of the formal record that the Pitkin County system produced in the aftermath of the events that followed. Those events arrived in June. For the moment, in the spring of 1977, the long table in the second-floor law library of the Pitkin County Courthouse remained the working space of a pro se defendant in the middle of a murder case. Legal papers lay across its surface. The shelves of volumes stood along the walls. The window was there as it had always been, looking out and down at the ground below from the height of the second floor. The sessions were logged. The transport van made its trips. The court calendar continued to move. Bundy sat at that table on the days he was brought to the courthouse with his papers and his legal volumes and the formal materials of his own defense arranged in front of him. He had been in that room on multiple occasions over the months since his arrival in Colorado. The room was known to him in the particular way that a space becomes known through repeated presence, its dimensions, its surfaces, its distances, its relationship to what lay outside its walls. The formal record of his time in that library is a record of authorized legal research in a designated space, conducted by a defendant exercising the right to represent himself in a proceeding in which the state of Colorado was the party on the other side. The arrangement continued through the spring. The pretrial stages moved toward whatever the calendar had set for the summer. The court file accumulated its papers. The jail logs recorded each day's transport and return. The window in the law library admitted whatever light was available from outside, at whatever angle the season and the hour produced, and the drop from sill to ground remained what it was, a fixed physical dimension of the room, present in the building's construction, present in the room where the defendant sat, working at the table with his papers, present and for a period of months, simply a feature of the architecture, unremarked in any supervision log. The courthouse in Aspen was a building that Bundy had come to know in the particular way that a person who moves through a space repeatedly and attentively comes to know it, not as an abstract layout, but as a set of physical realities, each one confirmed through presence. Below the Fission's floor corridor, the door to the library room, the table with its papers, the shelves along the walls, and beside the table, looking out and down from the height of the second floor, the window. Bundy sat at that table in the spring of 1977, with his legal papers arranged in front of him, the window at his side, the ground below at a distance that a person who had been attending to the room would have measured, however informally, simply by looking. The legal sessions in the library were formal occasions, supervised, logged, part of the documented proceeding. They were also hours spent inside the building that housed the court. The building had the layout it had. The defendant who was present in it across many sessions had the familiarity with it that extended presence produces. These are the conditions that the subsequent internal review examined when it turned its attention to the question of what the security arrangements had and had not accounted for before June of 1977. The record as it stands through the spring of that year is a record of a system operating by its rules, a defendant operating within the access that those rules provided, and a building that was what it was, a courthouse in a small mountain county. Its second-floor law library, furnished with legal volumes, and a long table, and a window that looked out over the ground below. The supervision logs continued. The transport van continued its runs between Glenwood Springs and Aspen. The pretrial calendar moved toward its next set of dates. The papers on the table in the law library represented the formal materials of a murder defense in progress. Bundy remained at the table. The window remained beside him. The drop to the ground below remained what it was, and the sessions continued, each one logged and authorized and documented in the formal records of the Picken County court system, which was moving step by step through its established procedures toward a trial. The image that the record holds from those months is a specific one, a second-floor room in a courthouse in a small Colorado mountain town, a long table covered with legal papers, shelves of volumes along the walls, a defendant working through the materials of his own case, with the particular focus of a person who has chosen to stand as his own advocate before the court. The room was quiet in the way that law libraries are quiet, the particular stillness of a space designed for close reading and careful thought. The defendant at the table was reading and thinking, and in the formal terms of the arrangement, preparing. The window was beside him. The room held what it held. The formal record of the pretrial period in Picken County is a record of legal proceedings moving through their established stages in the first half of 1977, documents filed, hearings held, research sessions conducted, transport arranged, and logged. It is also read with the later security review alongside it, a record of what the arrangements that governed those sessions did not account for, not through any single decision or any single moment of oversight, but through the accumulated effect of a system applying its standard procedures to a situation that the standard procedures had not been specifically designed to manage. The internal review put that conclusion into formal language. The conclusion is part of the record. Bundy, at the long table in the second-floor law library of the Picken County Courthouse, with his papers and his legal volumes, and the window beside him, opening onto the air above the ground below, was in the room that the legal system had authorized him to use, and that the security arrangements, as they existed through the spring of 1977, had left configured as it had always been, a working room in a courthouse, its windows unsecured, its sill at a known height above the ground, the distance from that sill to that ground, a fixed and measurable fact of the building that held it. The same access that the court had granted for the purposes of legal preparation had also, in the course of those months of research sessions, provided Bundy with a detailed and direct knowledge of the building around him, the room, the window, the floor, and what lay below. The law library sessions were documented as authorized legal research. They were also, in the physical reality of what they involved, extended time inside a specific space with specific features. The window was one of those features. It sat beside the table where the legal papers were spread. It was there each time the transport van brought him to the courthouse, and each time he was seated at that table to do the work the system had authorized him to do. It was there, and it was known, in the way that anything a person looks at repeatedly across a period of months is known, not abstractly, but in the specific and grounded terms of something observed and measured by simple presence. The window was open. That is what the first officers to enter the room found on the morning of June 7th, 1977, the second-floor window of the Picken County Courthouse Law Library, standing open, the latch unfastened, the frame pushed up from below. The room itself was otherwise in order. Legal volumes remained on their shelves. Papers sat on the long table in something approximating the arrangement they had been left in. The chair was pushed back from the table, as if someone had simply stood up and stepped away. What the room did not contain was Ted Bundy, who had been transported there from the Garfield County Jail in Glenwood Springs the previous day for a pretrial research session, and had, by the account the investigation would compile, gone out through that window sometime the evening before The drop from the sill to the ground below was estimated at approximately 20 feet. The physical record of the landing, the subsequent medical examination, and Bundy's own account provided after his recapture confirmed that he sustained injuries to both ankles when he hit the ground. The injuries were not incapacitating. They were enough to cause pain and limit his stride. They would accompany him through all 6 days of what followed. Pitkin County in June sits at elevation. The town of Aspen itself rests above 7,000 feet, and the terrain that rises from it on every side reaches considerably higher before it levels into high-altitude meadow or drops into adjacent valleys. The landscape in summer is open in some places and densely forested in others. Lodgepole pine and spruce on the slopes, exposed rocky ridgeline above the tree line, creeks running with snowmelt through the lower draws. It is terrain that requires both preparation and physical capacity to navigate with any reliability. And on the morning after the window was found open, Bundy had neither in sufficient measure. He had left the courthouse with what he carried, which by the investigation's assessment was minimal. The Pitkin County Sheriff's Office was notified within a short time of the window being discovered, and the response that followed was swift and broad in its initial mobilization. By the morning of June 7, 1977, the Colorado Bureau of Investigation had been contacted, and the Colorado State Patrol was involved in establishing roadblocks on the primary routes leading out of the Aspen area. The mountain geography that made the terrain difficult for a fugitive to navigate on foot also made the roads few in number and the choke points identifiable. Roadblocks went up on Highway 82, which follows the Roaring Fork River west toward Glenwood Springs, and on the passes that connected Aspen to the valleys and highways beyond. The logic of the initial response was grounded in the assumption that a person escaping on foot with ankle injuries would move toward roads and vehicles rather than deeper into backcountry, and the deployment of resources reflected that assumption. Aerial surveillance was added to the search. Helicopters moved over the terrain surrounding Aspen in the days that followed, tracking the grid patterns assigned to ground teams and searching open ground where a person moving through the landscape might be visible from above. The ground teams themselves worked through the trails and forested areas on the valley slopes, moving methodically through terrain that offered no easy passage and where the thin air at altitude made sustained physical effort more demanding than it would have been at lower elevation. The search was not a small operation. It drew personnel from multiple agencies and sustained itself across days rather than hours. Media coverage of the escape began almost immediately. Bundy's name had been in the news for more than a year at that point, carried through coverage of the DeRanch conviction in Utah, the Colorado extradition, and the pretrial proceedings in Pitkin County. The escape from the courthouse law library added a new dimension to that coverage. Reports went out through the regional press and moved nationally. The image of a defendant convicted in Utah and facing charges in Colorado, having jumped from a second-floor window of a courthouse where he had been permitted to conduct his own legal research, was one that generated considerable attention. The Pitkin County Sheriff's Office found itself managing both the search and the stream of media inquiry that accompanied it. For 6 days, the search did not produce Bundy. The roadblocks held and were maintained. The aerial surveillance continued. Ground teams covered the terrain available to them, and yet the perimeter, for all its initial sweep, did not close. The terrain itself was part of the reason. The backcountry surrounding Aspen is extensive, and the resources available to any search operation, however well coordinated, are finite against a landscape of that scale. The ankle injuries slowed Bundy's movement, as the subsequent investigation confirmed. But they did not stop it entirely. He moved through the terrain on the south side of town, working toward the trails and forested areas above Aspen in the days following the escape. What the documented record shows about those 6 days is partial by nature. Bundy's movements were reconstructed after his recapture from his own account and from the physical evidence the search teams later identified. Locations where he had sheltered, signs of passage in the terrain, the timeline assembled from what could be confirmed against what he reported. The account that emerged was one of incremental, difficult movement through high-altitude landscape, with limited food and impaired ankles, the days accumulating one after another as the search operation continued below and around him. The nights at that elevation and at that time of year are cold in a particular way. The temperature drops sharply after dark, even in June, the sky clear and the air carrying no warmth once the sun has gone from the high peaks. For a person without shelter, without adequate gear, and with ankle injuries that made covering ground difficult, the nights would have been among the more demanding aspects of those 6 days. This is not speculation. It is a reasonable inference from the documented conditions of the terrain, the season, and the physical state the medical examination later confirmed. The record does not elaborate on the experience of those nights. It notes only the physical evidence of how they were passed. At some point during the 6 days, Bundy made his way into a residential area near Aspen. The houses above town offered what the open terrain did not: warmth, food, the possibility of finding a vehicle. The investigation established that he broke into at least one property during the period he was at large, accessing shelter and supplies. This is documented in the account compiled after his recapture. He also, at some point, located and took a vehicle, which became the instrument of his eventual recapture. On June 13, 1977, 6 days after the window of the law library had been found open, an Aspen Police Department officer encountered a vehicle being driven in a manner that drew attention. The car was moving erratically on the roads near Aspen, the kind of movement that in a small mountain town at that hour made a stop appropriate. The driver of the vehicle was Ted Bundy. The car he had taken was stolen, a fact confirmed quickly, and his identity was confirmed through the stop. He had not escaped the Aspen area. The mountain roads, the roadblocks, the disorientation introduced by terrain he did not know well, and the physical limitations imposed by his ankle injuries had combined to keep him circling within a geography he could not successfully navigate out of. The investigation's account describes him as having become turned around on the mountain roads and having moved back toward Aspen rather than away from it. The recapture was made without significant incident. Bundy was taken into custody on that roadside on June 13, 1977, transported for medical assessment of his ankle injuries, and returned to custody. The 6-day search concluded not with a dramatic convergence of forces, but with a routine traffic stop on a road near the town he had left through a courthouse window less than a week earlier. The security review that followed the escape was the kind of institutional process that such events typically generate. A structured examination of what had occurred, conducted with the purpose of identifying the points at which the procedures in place had not held and establishing what changes were required. The review looked at the conditions of Bundy's transport from the Garfield County Jail to the courthouse, the supervision arrangements during law library sessions, the physical condition of the courthouse rooms he was permitted to use, and the specific vulnerability that the June 7th window had represented. What the review found, and what became part of the documented record of the case, was a set of identifiable gaps. The second-floor windows of the law library had not been assessed for escape risk at any point before the escape. They were operable windows in a room used for legal research, and the possibility that a defendant classified as high risk might use one as a point of egress had not been formally evaluated and secured against. The supervision during law library sessions had been insufficient for a defendant of Bundy's classification. The arrangements in place did not account for the specific risk he represented, and the periods during which he had been left with reduced oversight in that room had provided the operational window he needed. These findings were documented. They were specific. They named the conditions that had obtained and identified where those conditions had failed to meet the requirements that a defendant of Bundy's profile demanded. The review concluded with recommendations, and those recommendations were taken up in the form of changes to the protocols governing Bundy's custody and transport. He was returned to the Garfield County Jail in Glenwood Springs with a modified custody arrangement that reflected what the review had found. The case moved forward. The Colorado proceedings continued. The pretrial work resumed, albeit now under conditions that had been reviewed and in some respects tightened. The period between June 1977 and the end of the year was one in which the institutional adjustments prompted by the first escape were in place and operative. The question of whether they were sufficient would take months to answer, and the answer, when it came, would come quietly and in the dark. In Glenwood Springs, the Garfield County Jail is a structure whose physical scale and character are distinct from a maximum security facility. The building sits in a mountain town, and the conditions of its construction and operation reflected the carceral infrastructure of a jurisdiction of its size and history. It was not designed or equipped as a facility for holding defendants at the highest level of security classification. The post-escape modifications that followed the Aspen Courthouse review adjusted what could be adjusted within those constraints, and the custody arrangement for Bundy in the months after June 1977 was meaningfully different from what it had been before. But a building is what it is. Its ceilings run where its architects place them. Its crawl spaces exist where its structure requires them. The autumn of 1977 passed. The Colorado legal proceedings moved through their stages. Bundy's status as a pro se defendant continued, and with it the particular set of complications that self-representation introduces into the management of pretrial custody, the ongoing need for access to legal materials, the demands of the defense preparation schedule, the interface between the defendant's legal work and the custodial arrangements maintained by the jail. These pressures did not disappear after the first escape. They remained part of the operational reality that the Garfield County facility and the Pitkin County court system were managing together. The months between the recapture in June and the end of December 1977 represent a particular kind of interval in the documented record of the case, a period of resumed routine, of the ordinary machinery of legal process turning through its stages, of custody arrangements that were modified but not transformed. The first escape had produced a security review. The review had produced recommendations. The recommendations had been implemented as the institution understood them. And in the Garfield County Jail, in a cell that Bundy occupied through those months, the ceiling was what it was, and the light fixture above the bunk was where it had always been. What the record shows about how the second escape was prepared is documented in the account compiled after it succeeded. A reconstruction assembled from physical evidence, from the state of the cell when it was finally examined, and from what could be inferred about the time frame and method involved. The preparation was incremental and extended over a period of months. It did not announce itself. It was the kind of slow, quiet work that leaves almost no trace until the moment it is complete. Bundy reduced the food he consumed. Meals returned to the jail staff, with portions untaken, day after day, week after week, the portions small enough that the pattern did not immediately register as deliberate. Over several months, the cumulative effect of this reduction was a body that had lost an estimated 35 pounds from what it had weighed at the time of his incarceration. The significance of that reduction was not apparent to the jailers managing his custody. It became apparent only after the fact, when the dimensions of the crawlspace access point above his cell were measured and the weight loss was understood as having been calibrated to fit through an opening that would not otherwise have accommodated him. The ceiling of the cell contained a light fixture. Above the fixture, in the structure of the building, a crawlspace ran through the building's upper framework, the kind of maintenance access passage that exists in many structures of that era and design, running between the finished ceiling of the inhabited rooms and the underside of the roof and floor structures above. The opening through which the fixture was mounted into the ceiling represented, once the fixture was removed, an access point to that crawl space. The fixture had been worked loose over time, again incrementally, quietly, in the ordinary darkness of a jail cell at night, until it could be removed and replaced without detection. On the night of December 30th, 1977, Bundy arranged the materials in his cell: books, clothing, objects available to him within the confined space, beneath his blanket, in the shape of a sleeping figure. The arrangement was detailed enough to hold for a sustained period under casual observation, which is what jail checks typically involved: a look through the observation aperture, the apparent presence of a figure in the bunk, no cause for further investigation. The staged form in the bunk bought time. It was the central instrument of the escape's concealment, and it performed its function for an estimated 15 to 17 hours before a jailer became sufficiently suspicious on the afternoon of December 31st, 1977, to investigate more closely. By then, the cell had been empty since some time the previous night. The route Bundy took through the building, after pulling himself up into the crawl space, required navigating the passage's dimensions and direction, a dark, narrow space between the structural elements of the building, moving toward a point where the passage connected to or opened into another part of the facility. The crawl space led, according to the account assembled afterward, to a utility area within the building, and from the utility area, a further drop brought him into the residential quarters of the chief jailer, who was away from the building that evening. The apartment was furnished and ordinary: a coat rack, a door, the kind of domestic interior that any building housing both institutional and residential functions might contain, in the spaces between. Bundy walked through the apartment and out through the front door of the building. The night of December 30th, 1977, in Glenwood Springs was cold. The town sits at an elevation of approximately 5,700 feet, and December nights in the Colorado mountains carry the particular cold of high-altitude winter: dry, still, the temperature dropping well below freezing by the early morning hours. He walked away from the building through that cold and was not stopped. The account of what followed, the stolen car in Glenwood Springs, the drive to Denver, the flight to Chicago, the onward movement through Michigan and Georgia to Florida, is documented from the travel records that investigators traced after the escape was discovered. Each leg of the journey moved Bundy farther from Colorado, farther from the facility where, at that moment, the figure under the blanket still held the shape of something sleeping, still held the appearance, through the observation aperture, of a man in his bunk. Denver to Chicago, Chicago through Ann Arbor, Michigan, Atlanta, and then Florida, arriving in Tallahassee in early January 1978. The distance between Glenwood Springs and Tallahassee measured as road and air travel, is the kind of distance that, once covered, makes recapture by the originating jurisdiction essentially theoretical. The Colorado warrants existed. The investigative files were open, but the physical distance was what it was. In Tallahassee, Bundy rented a room in a boarding house a few blocks from the campus of Florida State University. The name on the rental agreement was Chris Hagen. The room was modest, a narrow bed, ordinary furnishings, a window looking out toward a college town in the first weeks of January. Stolen credit cards covered the immediate expenses. The social environment of a university town provided the kind of ambient activity and population movement through which an unrecognized person could move without attracting particular attention. Glenwood Springs was a long way behind him. The Garfield County Jail was a long way behind him. The cell with the staged figure beneath the blanket was a long way behind him. The figure under the blanket was still there, still holding its shape, on the afternoon of December 31st, 1977, when the jailer's suspicion finally moved from the casual observation of a form in a bunk to the closer attention that confirmed the cell was empty. The formal discovery of the escape came then, not in the hours immediately following the crawlspace exit, not in the cold early morning of December 31st, but in the afternoon of that day, 15 to 17 hours after the cell had been vacated, while the last day of the year moved through its ordinary stages in the town outside. The security review that followed the second escape was more extensive than the one that had followed the first. It examined the physical structure of the facility, the crawl space and its access point, the light fixture and the condition in which it was found, the pattern of returned meals over the preceding months, and the supervision arrangements that had not detected any of these developments over the period in which they had been occurring. The review produced a more detailed accounting of the conditions that had allowed the escape to proceed, and its findings were documented in the case record. What the first escape's review had found were gaps in supervision and unsecured windows. What the second escape's review found was something that had developed over a longer time scale and through a more patient method, a systematic preparation that had proceeded within the normal routines of custody without registering as significant at any individual point along the way. The returned portions of meals, the condition of the light fixture, worked loose over weeks. The weight loss, steady and incremental. Each of these, in isolation, was a fact that did not necessarily demand a particular response. It was only in retrospect, assembled against the outcome, that they formed a pattern. The crawl space itself, its dimensions, its location within the building structure, its connection to the areas it connected to, had not been assessed as an escape risk in the context of Bundy's custody. The physical architecture of the Garfield County Jail, which predated the specific security requirements his case had introduced, contained this passage in its structure as a matter of construction rather than of choice. The review noted this. It noted that a facility designed and built for a different era and a different population of detainees had been used to house a defendant whose classification, following the first escape, demanded a level of physical security that the building's structure did not straightforwardly provide. The review's findings were formal and documented. They sit in the records of the case as the institutional response to what had occurred, thorough in their identification of the conditions that had obtained, careful in their enumeration of what had not been detected. They are a portion of the larger record, and they remain in it. Back in the months of preparation that preceded December 30th, there is a particular quality to the documented picture, the cell, the bunk, the meals returned with small portions missing, the nighttime routine of incremental work at the ceiling, the weight coming off slowly over a period that stretched from the summer through the autumn and into the winter. It is a picture of patience applied to a specific and limited objective. The objective was the opening in the ceiling. Everything else, the food reduction, the physical conditioning, the nightly work on the fixture, served that single calculation. Jail cells are constrained spaces. The dimensions are fixed. The furniture is limited and fixed. The schedule of observation is regular and follows a pattern that over time becomes known to anyone living within it. What a detained person has access to is exactly what the institution permits, and no more. The preparation that the second escape required had to be conducted entirely within those constraints, without tools, without materials not available within the cell, without any activity that exceeded the apparent normalcy of a defendant in pretrial custody. The returned meals were ordinary returned meals. The work at the ceiling happened in the dark. The weight loss distributed across the months of autumn and early winter was not dramatic at any single point of observation. It was only when the cell was empty and the crawl space had been found and the dimensions of the opening had been measured that the months of preparation could be read clearly and completely. The record assembled then was detailed. It described the method. It described the timeline as far as it could be reconstructed. It described what had been found in the cell, the books and the blanket and the figure-shaped arrangement, and what had not been found, which was the person who had been housed there. The Colorado proceedings that had occupied the Pitkin County court system and the Garfield County Jail through 1977 were left without their primary subject. The case file remained open. The charges remained standing. The legal machinery that had been operating through the year was not dissolved by the escape. It continued, technically, in the absence of the person it concerned, waiting for a resolution that the flight to Florida had postponed indefinitely. In Tallahassee, the room rented under the name Chris Hagen sat a few blocks from the Florida State University campus. The university in early January exists in the particular quiet that falls between semesters, fewer students on the streets, the dormitories and residential areas partially emptied by the holiday period, the town in the process of resuming its regular rhythm, a man renting a room in a boarding house at that time, paying with cash supplemented by stolen credit cards, moving at a quiet pace through the streets of a college town. There was nothing in that picture that would have drawn particular attention. The name on the rental agreement was not his name. The distance from Glenwood Springs, Colorado, measured in the days that had elapsed since the Garfield County Jail's front door had closed behind him, was by then substantial. The staging in the cell had held for 15 to 17 hours. The drive from Glenwood Springs to Denver had been completed. The flight from Denver to Chicago had been boarded and flown. The further movement through Ann Arbor and Atlanta had been made. Each of these represented a stage in a journey whose full extent was not known to anyone in the Colorado investigative system until well after the cell was found empty. And even then, the documentation of the route took time to compile. The travel records were traced. The flight manifest was located. The movement south through Georgia to Florida was reconstructed from the evidence available. But the room in Tallahassee, with the name Chris Hagen on the rental agreement and the FSU campus a few blocks away, had been occupied for some days before anyone in Glenwood Springs knew the cell was empty. That interval between the moment the cell was vacated and the moment the staged figure was examined closely enough to confirm what it was, is the interval that defined how far the second escape had already succeeded by the time it was discovered. It was not a close thing. The 15 to 17 hours that the staged cell provided were enough to cover the distance that mattered. The security reviews pages, with their enumeration of the physical vulnerabilities and the supervision gaps and the pattern of returned meals that had not registered as significant at any individual moment represent the institutional account of how the second escape happened. They are thorough. They document the conditions. They note what was found and when it was found and what the examination of the crawl space and the ceiling and the cell established about the method and the time frame. They sit in the case record as the formal response to what had occurred, the retrospective reading of a preparation that had been conducted across months in a facility that was not equipped to detect it. The Garfield County Jail, with its crawl space running through its upper structure and its chief jailer's apartment on the other side of a wall that Bundy had identified and moved through, remained in Glenwood Springs. The Pitkin County Courthouse, with its second-floor law library and its window that had been found open on the morning of June 7th, remained in Aspen. The files of both the Colorado murder charge and the Duranch conviction in Utah remained in their respective systems, the paperwork continuing to exist in its folders and on its shelves, the official record of the proceedings persisting in the ordinary way that institutional records persist, regardless of the whereabouts of the person they concerned. The room in Tallahassee was quiet. The rental agreement bore the name Chris Hagen. The window of the room looked out toward a college town in the first weeks of January 1978. The distance between that room and the cell in Glenwood Springs was the distance between one end of the country and the other, measured in miles and in the days of travel that had covered them, and that distance had been fully covered, quietly, incrementally, by stages, before anyone in Colorado had confirmed that the cell was empty and the figure in the bunk was made of books. In the months that followed his recapture in June of 1977, the cell Bundy occupied at the Garfield County Jail in Glenwood Springs, Colorado, was quiet in the way that cells tend to be. A bunk, a small fixed table, a light fixture mounted in the ceiling. The ordinary geometry of institutional confinement, repeated in facility after facility across the country, designed for security through its very plainness. What the record shows is that Bundy began, in that quiet, a process of observation and preparation that would unfold over several months before it produced any visible result. The meals came at regular intervals. Jailers brought food, and food was returned. What the documentation from this period indicates is that Bundy consistently returned portions of his meals, not dramatically, not in ways that drew sustained attention, but steadily, over weeks and then months. The portions returned grew slightly larger than the portions consumed. The effect on his physical condition was gradual. 35 pounds, by the accounting that investigators and jail records later confirmed, came off over the course of that preparation period. 35 pounds removed, slowly and quietly, from a man who had spent considerable time looking at the ceiling of his cell. The ceiling was where the plan resided, in the most literal sense. Above the light fixture, the building's structure contained a crawl space, a passage running through the institutional architecture of the jail, accessible through an opening that the fixture concealed. What the fixture required to become an opening rather than a fixture was the kind of incremental, patient work that leaves almost no record at all. The screws and fastenings that held it in place were worked at over time. The fixture was loosened by degrees. Nothing about this process announced itself to the jailers making their rounds, and nothing about the cell on any given day suggested that anything was being prepared at all. The books on the table, the blanket on the bunk, the particular, ordinary stillness of a cell in which a man spends his days reading and writing legal documents, preparing his defense for the trial proceedings that were continuing through the Colorado courts. All of this was ordinary. All of it remained visible to anyone who looked. The ceiling remained as it appeared to be, and the fixture remained in its housing, and the months continued to pass. What Bundy had identified, in addition to the crawl space above his cell, was the layout of the building that surrounded it. The Garfield County Jail was not a large facility. The crawl space, by the account that investigators later reconstructed, ran through the building's structure in a way that opened not into another secured area, but into a residential section of the building, the living quarters occupied by the chief jailer, whose apartment was contained within the jail structure itself. This was a detail of the building's architecture that would prove to be significant, and what the path from the cell to the crawl space to the apartment existed as a physical fact of how the building had been constructed, independent of anyone's intention. December came. The investigation into Bundy's preparatory activities during this period was conducted after the fact, and what it reconstructed was largely circumstantial. The reduced food portions confirmed through jailer testimony the physical change in his appearance noted by those who had contact with him, the loosened fixture confirmed at the scene. What could not be reconstructed with precision was the exact sequence of decisions that led him to choose December 30th, 1977, as the night on which everything that had been prepared would be used. The night of December 30th was a quiet one at the Garfield County Jail. The holiday period had reduced activity in and around the facility. The chief jailer, whose apartment occupied the section of the building above and connected to the space Bundy would move through, was out for the evening. These were circumstances that the documentary record confirms, but does not explain in terms of how or whether they were known in advance. The post-escape review noted the timing as significant without establishing definitively how the information had been obtained or whether it had been obtained at all, as opposed to being incidentally fortunate. What the record shows is what happened. Bundy removed the light fixture from his cell ceiling. He had reduced his physical size over months of deliberate preparation, and the opening above the fixture, narrow, dark, running through the interior of the building, was now sufficient to admit him. He pulled himself up through the opening and into the crawl space above. The crawl space was a passage through the building's structure, not designed or intended for human transit. Its dimensions defined by the requirements of electrical and mechanical systems, rather than by any consideration of the person who would eventually move through it. The path through it led from above the cell block to a utility area, and from there to the interior of the chief jailer's apartment. The apartment, on the night of December 30th, was unoccupied. The chief jailer was not home. The door of the apartment led to the outside. What the account describes, reconstructed from physical evidence and the post-escape review, is that Bundy moved through the crawl space, dropped into the apartment, and walked out through the front door. No alarms documented. No encounter with personnel. The door opened and closed, and he was outside the Garfield County Jail, on the street in Glenwood Springs, Colorado, in the cold of a December night. Back in the cell, the bunk held what had been arranged beneath the blanket. Books, clothing, materials shaped and positioned under the fabric to suggest the form of a sleeping figure. The fixture had been replaced above the opening. The cell, to anyone passing and looking through the observation window in the ordinary rhythm of a nighttime shift, presented what it was intended to present: a man in his bunk, apparently asleep. The particular quality of a cell at night, the low light, the stillness, the intervals between rounds, was what the arrangement relied upon. Jailers made their checks. The hours passed. The early morning hours of December 31st arrived, and the cell continued to present what it had been staged to present. What the post-escape timeline established is that the deception held for somewhere between 15 and 17 hours. From the departure on the night of December 30th to the afternoon of December 31st, when a jailer, looking more carefully or responding to something in the appearance of the figure that had not changed position, became suspicious and the cell was found empty. 15 to 17 hours. The number appears in the post-escape documentation as a range rather than a precise figure because the exact time of departure could not be pinpointed from the jail's records. And the exact time at which a jailer first became sufficiently concerned to investigate was similarly difficult to establish with precision. What the range confirms is the basic fact of how long the arrangement of books and blankets held before anyone looked more carefully than the arrangement required. By the afternoon of December 31st, when the cell was confirmed empty, Bundy had been outside the facility for the better part of a day. What the investigation reconstructed of his movements in the hours immediately following the escape was drawn from physical evidence, witness accounts gathered after the fact, and the subsequent travel documentation that became available once the trail had been established. The picture was incomplete in its early detail and became clearer only as the distance from Glenwood Springs grew larger. A car was taken in Glenwood Springs. The vehicle, reported stolen and identified later as part of the investigative reconstruction, provided the means to leave the immediate area. The roads out of Glenwood Springs in December, in the mountain terrain of western Colorado, are limited in number. The highway through the valley follows the Colorado River, and it was on that highway that Bundy drove east, away from the ski resort town and toward the larger population centers further along the corridor. Denver. The distance from Glenwood Springs to Denver is roughly 160 miles by road, through mountain passes and down into the high plains, where the Front Range gives way to the broader expanse of the western interior. What the documentation shows is that Bundy arrived in Denver, and from there accessed the commercial aviation network that connected the city to the rest of the country. An airport in Denver in late December of 1977 would have been occupied with holiday travelers, the kind of transient, moving crowd in which one person among many is simply one person among many. A flight to Chicago. The direction of travel was east, away from the jurisdictions in Colorado, Utah, and Washington, where the criminal proceedings and investigative files associated with his case were concentrated. Chicago was a transit point rather than a destination. What the record of his subsequent movements shows is that the trajectory continued eastward through Ann Arbor, Michigan, and then south toward Atlanta, Georgia, and from Atlanta toward the southeastern coast. The route, as it was reconstructed after the fact, was not a direct line, but a series of steps through the connected infrastructure of American long-distance travel, each step carrying him further from Glenwood Springs. Ann Arbor is a university town in southeastern Michigan, and Atlanta is a major transit hub in the American South. What connected these stops to the eventual destination was not obvious from the geography alone. The route was indirect, a pattern of movement that reflected the availability of connections rather than a planned itinerary in its particulars. What the documentation shows is the general shape of the journey: the Rocky Mountain interior, the Midwest, the South, the flat coastal lowlands of northwestern Florida, and then the town of Tallahassee. Tallahassee, in early January of 1978, was a college town at the start of a new semester. Florida State University occupied a substantial portion of the city's activity and character, its campus and the streets surrounding it, populated by students returning from the holiday break, by the ordinary commerce and movement of a mid-sized southern city, by the ambient, unremarkable activity of ordinary daily life. A man arriving with a bag, looking for a room, presenting himself as a graduate student from somewhere else, was not an unusual figure in that environment. The environment did not require him to be unusual. The boarding house was located a few blocks from the Florida State University campus, on a street of ordinary residential architecture in the college neighborhood that surrounded the university. The room Bundy rented was small in the way that boarding house rooms are small. A bed, a window, the basic furnishings of temporary accommodation. The name he gave on the rental agreement was Chris Hagen. The name meant nothing to anyone in Tallahassee, and the rental agreement was a piece of paper with a name on it, filed in the ordinary way of such documents. The distance from the Garfield County Jail in Glenwood Springs to the boarding house room in Tallahassee is approximately 2,000 miles, depending on the route taken. What the reconstruction of Bundy's movements established was that this distance had been covered in roughly the first week of January 1978 through a sequence of transportation stages that left a trail of records, flight manifests, car rental documents, transit records that investigators would later work backward through to establish the timeline. At the time, in the first days of January 1978, those records were unconnected. Each one existed separately in the ordinary administrative systems of ordinary American travel, without any mechanism to draw them together into a coherent picture. The Garfield County Sheriff's Office, on the afternoon of December 31st, 1977, was managing the immediate response to the discovery of an empty cell. The notification process moved outward from that discovery to the Colorado Bureau of Investigation, to the network of law enforcement agencies that had been part of the case, to the communication systems that disseminated wanted person information across state lines. The alert that went out described a white male, height and weight updated to reflect the physical changes of the preceding months. Last known location, Glenwood Springs, Colorado, considered capable of crossing state lines. Direction of travel unknown. Direction of travel unknown. That phrase, in the terminology of law enforcement bulletins, describes the condition of an investigation in its earliest hours, when a subject has had time to move and the trail has not yet been established. What it meant, practically, in the first days of January 1978, was that the search for Bundy was being conducted in the absence of a clear sense of where he had gone. Colorado law enforcement focused initial efforts on the surrounding region, the mountain corridor, the neighboring states, working from the assumption that the initial movement would be limited by the terrain and the conditions of a December escape from a mountain town. The terrain around Glenwood Springs in December is not accommodating. The temperature drops significantly at altitude after dark. The passes are subject to snow and ice. A person on foot in the mountain environment of western Colorado in winter would face conditions that the first escape in June of 1977 had not involved. The mountain terrain outside Aspen in summer was challenging but navigable. The winter equivalent was more serious. If you were ze Charles not Breram and seal tread before Bevert, to where ze were swung wars, and you had rode the bathroom or tangents. What the car taken from Glenwood Springs represented in this context was the means to move through, rather than on foot through that terrain, and to do so quickly enough to reach the highway system before the discovery of the empty cell narrowed the options available. The post-escape review at the Garfield County Jail was a document produced from the particular frustration of an institution that had already been the subject of scrutiny following the first escape and now found itself accounting for a second. What the review identified was the crawlspace access point above the cell as a structural vulnerability that had not been addressed or assessed as a security concern. The light fixture and what it concealed had not been part of the facility's security evaluation in the period between the first recapture and the second escape. Whether the fixture had been identified and assessed and found to be acceptable, or whether it had not been formally assessed at all, was a question the review addressed in measured institutional language that acknowledged the gap without assigning specific individual responsibility for it. The reduction in Bundy's physical size, 35 pounds over several months, was noted in the review as a factor that the regular contact with jailers and personnel had apparently not flagged as a preparation indicator. The meal portions returned over time, the visible change in his appearance, were details that existed in the ordinary records of daily jail operations. The review noted these as factors, while acknowledging the difficulty of identifying deliberate preparation in the pattern of daily jail management, where many variables operate simultaneously and individual observations are not always connected to a broader pattern in real time. Real time is the relevant frame. What the review was accounting for, ultimately, was the difference between what was visible in the record and what was understood from that record as it was being made. The reduced meals were visible. The loosening fixture was not visible from outside the cell. The physical change was visible to those who had regular contact. The connection between these observations and a coherent preparatory plan was not established until after the cell was empty, when the retrospective examination of the record produced a sequence that had not been apparent as a sequence while it was unfolding. The boarding house on the street near Florida State University held its ordinary routine through the early days of January 1978, but the other residents of the building moved through their days in the normal way of people sharing a residential structure. The kitchen, the common areas, the coming and going of ordinary life in a college neighborhood. The man in the room, registered as Chris Hagen, was present in this routine without distinguishing himself from it in ways that attracted attention or generated comment. Stolen credit cards funded the expenses of the first weeks. The cards had been taken at earlier points and were used to cover the costs of accommodation and daily living in Tallahassee. Their use left a record, transaction records that would later become part of the investigative trail, but the record was not being monitored in Tallahassee in the first week of January 1978 because the location of the person using them had not yet been established. The cards were used and the transactions occurred, and the record accumulated in the ordinary administrative systems of the financial institutions involved, waiting to be gathered and examined when the trail was eventually established. The Florida State University campus was a few blocks from the boarding house, and the social geography of the college neighborhood extended in all directions from it. The bars and coffee shops and ordinary commerce of a university district, populated in the first weeks of January with the familiar activity of a semester beginning. What the documentation of this period established, reconstructed later, was that Bundy moved through this environment in the ordinary way of someone who had found a temporary location and was managing the practical requirements of daily life within it. The alias held, the rental agreement sat in its file. Glenwood Springs is 2,000 miles from Tallahassee. The Colorado River runs through the valley below the town, cold and fast in December, the mountains rising on both sides. The jail sat in that geography as a physical fact of the town, its records and its empty cell, a matter now being managed through the formal systems of law enforcement notification and interstate communication. The wanted bulletin circulated. The agencies coordinated. The search proceeded through the channels available to it. What the channels available in early January 1978 did not yet include was a confirmed direction of travel. The flight from Denver had not yet been identified as part of the trail. The stops in Chicago and Ann Arbor and Atlanta had not yet been connected to the departure from Glenwood Springs. The boarding house in Tallahassee and the name Chris Hagen, written on the rental agreement, were unknown to anyone outside that building. The room was just a room, in a house on a street, in a college town in the Florida Panhandle, and the man in it was to anyone who encountered him in the ordinary course of daily life, simply a person in a place. The crawl space above the Garfield County jail cell was still there, of course. The fixture had been replaced before Bundy left, and the opening it had concealed was still in the building's structure, above the empty bunk, above the books and clothing that had been arranged beneath the blanket and had held their arrangement for 15 to 17 hours in the low light of a December night. The cell had been processed as a scene. The items on the bunk had been documented. The fixture had been examined. The crawl space had been accessed and its route through the building traced, and the point of egress into the chief jailer's apartment confirmed. The path was there in the building, fully visible now, every step of it documented and understood. What it had been before December 30th was equally present in the building's structure. The same crawl space, the same dimensions, the same route through the same architecture. What had changed between the time of Bundy's arrival at the facility and the night of his departure was not the building, but the preparation that had been conducted within it, steadily and quietly, over the months between the summer recapture and the December departure. 35 pounds. The fixture worked loose by degrees. The meal portions returned, slightly larger than the portions consumed, week after week. The months of quiet observation in a cell that appeared, from outside, to be exactly what it was required to appear to be. The record of this preparation exists in the retrospective documentation, the post-escape review, the jailer testimony, the physical examination of the cell and its ceiling, rather than in any contemporaneous record, because contemporaneous records captured what was visible in the ordinary course of operations, and what was being prepared was not visible in that way. The boarding house room in Tallahassee had a window that looked out toward the street. January in Florida is mild compared to January in western Colorado. The temperature in Tallahassee in early winter sits in a range that permits ordinary outdoor activity without the need for heavy clothing, and the light that comes through a window in a ground floor room in a residential neighborhood is the ordinary light of a mild southern winter, flat and pale in the morning and warm in the late afternoon. The room was ordinary in every respect that would register on casual observation, and casual observation was what it received. The rental agreement with the name Chris Hagen on it was a physical document, a piece of paper with handwriting on it, sitting in whatever administrative file the boarding house maintained for its residents. Rental agreements are not dramatic objects. They record a name and a date, and a payment, and a duration, and they sit in their files in the ordinary way of administrative records, everywhere, accumulating with the other documents of daily institutional life, without calling attention to themselves. What the record of this period holds, taken in its entirety, is a documented sequence of preparation and movement that connects a cell in Glenwood Springs, Colorado, to a room in Tallahassee, Florida, through a series of stages, each of which left some form of trace in the systems it passed through. The traces existed. They were not connected in real time because the systems that contained them were not connected to each other in the way that would have been required to draw the picture as it was being made. The picture existed only in retrospect, assembled from the records once the trail had been established and the direction of travel confirmed. In the winter of 1977 and into January of 1978, Those records waited in their separate locations: the jail's documentation of the cell and its contents, the flight manifests and transit records of the journey east, the rental agreement in a boarding house file in Tallahassee, each one a piece of a picture that was not yet being assembled, in a system that did not yet know which pieces it was looking for. The cells in the Garfield County Jail were quiet in January 1978, as they had been quiet in the months before. The bunk in the cell that had been occupied was as it was, the ceiling above it now assessed and documented. The building's crawl space had been examined, and its route confirmed, and what the examination confirmed was that the route had always been there, in the building's structure, running through the walls and above the ceilings of the facility in the way that such spaces run through institutional buildings everywhere. The light in Tallahassee came through the boarding house window in the early morning and moved across the room in the ordinary way of winter light, unhurried and pale, covering the narrow bed and the ordinary furnishings of a small room rented under a name that meant nothing to anyone outside the building, on a street a few blocks from a university campus, in a city that was, in every operational sense, 2,000 miles from the empty cell in Colorado. And the document that noted, in the measured language of an institutional review, what the crawl space had contained, and where the fixture had been, and how the bunk had looked in the low December light, to the jailers who had passed it and found it. Each time, exactly as they expected it to be. The name on the rental agreement sat in its file. The room held its ordinary quiet. The distance from Glenwood Springs was the distance it had always been, 2,000 miles of road and sky, and the connected infrastructure of American travel, all of it traversed and documented, and waiting in the separate systems that had received each piece of it, the record complete in its parts, and not yet assembled into its whole, resting in the particular stillness of administrative documents that have not yet been gathered into the larger account. They will eventually be required to form. A Pensacola street in the early morning hours of February 15th, 1978, was quiet in the way that streets are quiet before the day has organized itself. The dark still settled, the traffic sparse, the ordinary rhythms of a Florida coastal city not yet resumed. Officer David Lee was on patrol when he ran the license plate of a Volkswagen Beetle, moving through that early morning quiet. The return came back, indicating the vehicle had been reported stolen from Tallahassee. He initiated a traffic stop. What followed was not the clean procedural exchange of a routine stop. The driver resisted. There was a physical struggle, and the man behind the wheel made a brief attempt to flee on foot before Officer Lee took him into custody. The arrest was made in the street, in the dark, on a February morning that had begun as ordinary as any other. Fingerprints confirmed the driver's identity within hours. The name that came back was Ted Bundy, and at the time of that confirmation, law enforcement agencies in Colorado had been looking for him for more than 6 weeks. The distance between Glenwood Springs and Pensacola is considerable. It is the length of nearly the entire continent, measured east to west, and the route Bundy had taken between those 2 points had passed through Chicago, through Michigan, through Georgia, before arriving in Florida. The confirmation of his identity in a Pensacola police facility on the morning of February 15, 1978, was the first fixed point in the record from which all the subsequent legal proceedings would follow. A moment documented in an arrest report that named the officer, the vehicle, the time, and the charge, the way arrest reports do, in the flat administrative language of institutional record keeping that holds the outline of events without much concern for their weight. Bundy had been in Florida for roughly 6 weeks before Officer Lee pulled behind that Volkswagen. He had been living in Tallahassee under the name Chris Hagen in a boarding house room a few blocks from the Florida State University campus, and the name on the rental agreement was the only identification the boarding house had. The alias had held for the duration of his time in the city. He had used stolen credit cards to manage his expenses. He had moved through the social environment of the college town without drawing the sustained attention of local law enforcement, and no agency operating in Florida during those 6 weeks had formally confirmed that he was in the state. The distance he had put between himself and Colorado and the name he had placed over his own had been sufficient for a time to keep the record incomplete. The arrest record filed in Pensacola on February 15, 1978, began the process of making it complete again. The name Ted Bundy, confirmed by fingerprints, was now attached to a Florida arrest. Investigators in Colorado were notified. The record that had been running in parallel, the Garfield County escape report, the subsequent alerts, the 6 weeks of no confirmed location could now be updated with a final entry. He had been found. He was in custody. The precise physical location, a Pensacola holding facility, on the morning of February 15, 1978, was now part of the file. The Florida proceedings that followed were organized around events that had taken place in Tallahassee and in Lake City, and the legal process of bringing those proceedings to trial took time measured in months rather than weeks. The primary trial centered on events at the Chi Omega sorority house at Florida State University on the night of January 15, 1978, was eventually moved from Tallahassee to Miami. The reason documented in the legal record was the level of pretrial publicity in Tallahassee, the extent to which the case had already occupied the local media landscape made it difficult to assemble a jury in that city with no prior exposure to the case's details. Miami was selected as the venue, and the trial was scheduled and held there in the summer of 1979. The Miami courtroom in which the proceedings took place was a working legal space, a jury box, a witness stand, a bench, a gallery, the ordinary furniture of American formal legal procedure. What distinguished it from most American criminal trials of its period was the presence of a television camera. The Florida Bundy trial became one of the first criminal trials in the United States to be broadcast live on television, and that fact placed it into a different register of the record than most criminal proceedings occupy. The transcripts exist, as transcripts always do, in the court archives. The filmed record also exists in the broadcast archives of the stations that carried the proceedings and in the institutional holdings of organizations that maintain records of notable American legal history. The trial was watched as it happened. It was documented in real time by cameras in addition to court reporters, and the documentation that resulted is held in more than one form. Bundy had chosen to represent himself in the Florida proceedings, as he had done in Colorado. The pro se designation, a defendant conducting his own legal defense, appearing before the court as his own attorney, was not unusual in itself, though it was uncommon in a case of this seriousness. The decision placed him in direct contact with the proceedings in a way that a defendant represented by counsel typically is not. He cross-examined witnesses. He made legal arguments before the bench. He addressed the jury. The transcripts of these exchanges are part of the trial record, filed in the court archives where Florida v. Bundy is maintained, and they document the legal strategy as it was executed in the formal language of courtroom proceedings, without editorial commentary on its adequacy or its direction. The jury in Miami deliberated and returned its verdict in July 1979, 2 counts of first-degree murder, multiple counts of attempted murder. The verdict was documented in the court record in the standard form. The count, the finding, the jury's statement, and the sentencing followed in the formal sequence that Florida law required. Judge Edward Cowart presided. The death sentence was entered into the record in the judge's formal language, the language of sentencing, which names the offense, the finding, and the penalty, and places them together in a document that becomes part of the permanent court file. The sentence was death by electric chair. Judge Cowart was known in accounts of the trial that were reported at the time and have been documented since for conducting the proceedings with a particular quality of formal decorum. The sentence he delivered was delivered in that register, measured, legal, the instrument of the court, rather than of any individual voice. What the transcript shows is the formal language of a capital sentence entered into the record of a Florida court in the summer of 1979 in a Miami courtroom that had been carrying a television camera since the trial began. The sentence was part of the broadcast record as well as the legal one. A second trial followed in Orlando in a separate proceeding. The charge was murder, the death of a 12-year-old girl named Kimberly Leach in Lake City, Florida, in February 1978, approximately 2 weeks before Bundy's arrest in Pensacola. The Lake City case had its own investigative record, its own evidentiary file, its own chain of documentation built up by the investigators who had worked it in the months between the discovery and the arrest. The Orlando trial produced a second guilty verdict and a second death sentence, and both sentences were entered into the Florida court records that now held Bundy's legal history in the state. The years between sentencing and execution were occupied, as capital cases in the United States typically are, by the legal review process, the appeals system that requires sentences of this kind to be examined at multiple levels of the court structure before they are carried out. That process runs on its own timeline, which is not the timeline of the original crime or the original trial, but the timeline of the appellate courts and the procedural requirements they apply. The documentation of those years exists in the appellate records of the Florida courts, in the files maintained by the legal teams involved, and in the administrative records of the Florida Department of Corrections, where Bundy was held on death row at Florida State Prison in Ryford. Florida State Prison sits in a flat landscape in North Florida, surrounded by land that offers no particular topographical feature to orient a visitor. No mountains, no coastline visible, no city nearby. The facility is a concrete and brick structure, and the records it maintained for each person in its custody were administrative in nature: intake documents, housing assignments, medical records, the regular entries of institutional management. The record of Bundy's time there accumulated over nearly a decade, from the time of his sentencing in 1979 to the execution date in January 1989. The file that Florida State Prison maintained for that period is held in the administrative archives of the Florida Department of Corrections, where the records of all former inmates are held, indexed, accessible by request through the established channels of Florida's public records system. The appeals process moved through its stages. Various legal challenges to the convictions and the sentences were filed, reviewed, and decided by the courts assigned to hear them. The record of each filing, each decision, each further appeal is part of the documentary history of the case, distributed across the Florida court system and the federal courts that reviewed the case at the relevant points in the appellate process. None of the appeals produced an outcome that altered the convictions or the sentences. The process reached its end, and the date of execution was confirmed and set. On January 24, 1989, Ted Bundy was executed by electric chair at Florida State Prison in Ryford. The time recorded in the prison's administrative log was 7:16 a. The attending physician pronounced death shortly after. The announcement was made by Florida prison officials to the assembled media in the formal language of such announcements: name, date, time, method, location, the language that places an execution into the institutional record in the same register that every other administrative event at the facility would be recorded. The documentation filed that morning, the log entry, the physician's notation, the official announcement, is part of the Florida Department of Corrections permanent records. The media presence outside Florida State Prison on the morning of January 24, 1989, was considerable. Reporters and camera crews had gathered in the hours before the scheduled execution time, and the announcement was made to them when it was made. The broadcast and print records of what was reported that morning are held in the archives of the organizations that reported it. The New York Times filed a report. The major wire services filed reports. Florida's newspapers reported extensively. The documentation of the public record of that morning is distributed across the media archives of January 1989 in the way that significant news events are, in many places at once, in many formats, preserved in the physical and digital holdings of the institutions that produced it. What the records assembled from those archives show, taken together, is a legal history that ran from August 1975, the traffic stop in Granger, Utah, where a highway patrol sergeant's flashlight moved across the interior of a tan Volkswagen Beetle and found what it found, to January 1989, when the final entry was made in the Florida prison log. That is 13 and a half years of documentation, arrest reports, trial transcripts, appellate filings, sentencing orders, prison administrative records, execution logs. The accumulation of those years of record keeping is held in the archives of Utah, Colorado, and Florida, 3 state systems, each maintaining its own portion of the case history, the portions together forming the complete record of the official proceedings. The Utah portion begins with the traffic stop and moves through the Durant trial and the sentence to Utah State Prison. Those records are held in the Utah State Archives and in the files maintained by the relevant court systems, the trial transcripts, the sentencing documents, the prison intake records from the 1976 commitment. Defense and State of Utah's portion of the record is comparatively brief in terms of its duration. The legal proceedings there were concluded relatively quickly, but its documents are the foundation on which everything that followed was built. The identification Carol Durant made in a Utah lineup in 1975 and the conviction that followed in 1976 are in those files. They are filed and indexed. They are held. The Colorado portion is longer and more complicated, covering the extradition from Utah in January 1977, the pretrial proceedings in Pitkin County, the 2 escapes and the investigations that followed them, and the eventual decision after Bundy's conviction in Florida about how to handle the Colorado charges that had been pending since 1977. Colorado's records are distributed across the Pitkin County court system, the Garfield County records, and the Colorado Bureau of Investigation's files on the escapes and the subsequent manhunts. The Garfield County Jail, where the second escape originated, would have maintained its own administrative records of the incident, the post-escape review, the documentation of how the ceiling access point was used, the timeline of discovery, and those records are held in the institutional archives of the facility and the county that operated it. The Florida portion is the largest, covering the arrest in Pensacola, the investigation in Tallahassee, and Lake City, 2 separate trials in 2 separate cities. the sentencing proceedings, nearly a decade of death row housing, the full appellate record, and the final administrative documentation of the execution. That material is held across multiple Florida institutions, the Leon County court system, which had jurisdiction over some early Florida proceedings, the Dade County court system, where the Chi Omega trial was held, the Columbia County records connected to the Lake City case, the Orange County court system, where the Leach trial took place, the Florida Supreme Court records from the appellate process, the federal court records from the federal appeals, and the Florida Department of Corrections Administrative Archive. The volume of documentation is substantial. The systems that hold it are durable. The case has attracted, since Bundy's execution in 1989, a significant volume of journalistic, academic, and popular attention. Books have been written about it, documentaries have been produced, podcasts have addressed it at length. The popular record of the case, the accounts that circulate in media outside the formal legal archive, is extensive, and it is not uniformly precise. Details that appear in the formal record are sometimes reproduced in popular accounts, with alterations, some minor and some less so. The case file, in its formal archival location, contains what it contains regardless of what any particular popular account has said about it. The two records, the formal archive and the popular one, exist in parallel, and they do not always agree, and the formal one was produced closer to the events and by people whose obligation was to document accurately rather than to narrate compellingly. Detective Robert Keppel, who had worked the original King County investigation in Washington, and whose name appears in the investigative records from the earliest stages of the case, conducted a series of interviews with Bundy in the days before the execution. Those interviews have themselves become part of the record, documented and published and discussed. Bundy, in the period before January 24, 1989, spoke with investigators about crimes in multiple states, and the information he provided in those conversations has been assessed, compared against existing case files, and used to inform ongoing investigations into cases that remained open. Some of what he said has been corroborated by independent evidence. Some has not been fully verified. The interviews exist in the record as interviews, documented conversations, the content of which is noted and assessed and held alongside the corroborating or non-corroborating evidence that investigators brought to them. The questions that remain open in the case are not questions about the Florida convictions, which produced verdicts and sentences that were fully reviewed and upheld through the appellate process. They are questions about the full scope of the crimes, the number, the locations, the cases in other states and other jurisdictions that may or may not be attributable to Bundy, based on evidence that is in some instances still incomplete. Investigators in several states have reviewed cold case files with Bundy's known movements in mind. Some of those reviews have produced formal conclusions, others have not. The cases that remain open in those files are still held in their respective investigative systems, still indexed, still waiting for evidence that would allow a conclusive determination to be made. The King County case file, the one that began in the summer of 1974, when detectives began receiving tip sheets and Robert Keppel organized them into folders, is part of those holdings. The tip sheets from 1974 and 1975, the index cards, the cross-referenced names and dates, the material that accumulated through that initial investigation, are held in the King County archives. The case records from Washington that were later connected to Bundy's name are part of the formal investigative history. They are still there in the sense that archived investigative material is still there, present in the storage system, indexed, retrievable by the agencies that hold them. The record of what was known and what was not known and when, preserved in the flat institutional language of case management. The Garfield County Jail in Glenwood Springs, from which the second escape originated in December 1977, continued to operate after Bundy's escape. The security review that followed the escape produced its findings, and those findings informed changes to how the facility managed high-risk detainees. The specific physical access point that Bundy used, the ceiling crawl space, the loosened light fixture, the distance between his cell and the chief jailer's apartment, is part of the documented record of that escape and the review that followed it. The building itself has changed over the decades since 1977. What the review documented at the time is held in the record of what was found, in the language of institutional self-examination that follows an incident of this kind, noting what failed and what was subsequently addressed. The Pitkin County Courthouse in Aspen, where the first escape took place in June 1977, is also still standing. The second-floor law library, the window through which Bundy jumped on the morning of June 7, 1977, the drop to the ground below, those physical features are part of a building that continues to exist. The legal proceedings that passed through that courthouse in 1977 are part of its institutional history, held in the court records of Pitkin County alongside every other proceeding the court has handled. The review of the first escape security failures is part of those records as well, noted and archived in the way such reviews are, the language quiet and administrative, the findings named without drama. The photograph of the Pitkin County Courthouse that appears in various published accounts of the case shows a building that does not look like a prison. It looks like a courthouse in a Colorado mountain town, which is what it is. The second-floor window that appears in some of those photographs looks like a courthouse window. Nothing about the exterior of the building announces the event that occurred there in June 1977. The building holds its history the way buildings do, in the documents filed inside it, in the institutional memory of the people who work there, and in the record that the outside world has produced about what happened within its walls. The window is still a window. The drop to the ground would still be roughly 20 feet. These are physical facts about a building, and they exist in the same quiet, persistent way that physical facts about buildings exist. The Florida State Prison at Ryford holds its own history in the same manner. The administrative records from 1979 to 1989 are in the archive. The execution log entry from January 24th, 1989 is in the archive. The building continues to operate as a correctional facility. The records it generated during Bundy's time there are indexed and held in the Florida Department of Corrections system, accessible through the channels that Florida's public records laws establish. Present in their folders in the way that records are present in folders. The paper still there, the ink still legible, the dates and times and names still what they were when they were first written down. It is now more than 3 decades since the morning of January 24th, 1989. The case file, taken as a whole across the 3 states that hold its components, is complete in the sense that no further legal proceedings are pending, and no further entries will be made in the administrative files of any corrections facility. The record is closed at its formal legal end. The investigative records remain open in the narrower sense. Some cold cases connected to Bundy's name and known movements have not been conclusively resolved, and the investigators assigned to those cases continue to hold them in the active portions of their files, even when the pace of new development is slow. What has changed since 1989 in terms of the investigative tools available to cold case reviews is considerable. DNA technology has advanced substantially. Database systems now exist that were not operational during the period of the original investigations. The Violent Criminal Apprehension Program, VICAP, which did not exist in functional form when the King County Task Force was working its tip sheets by hand in 1974, now provides a mechanism for connecting cases across jurisdictions. These developments have not reopened the Florida convictions, which are settled matters of legal record. They have, in some instances, been applied to the connected cold cases with varying results, and the reviews that have been conducted using these tools are documented in the files of the agencies that conducted them. The broader record of the case, the one that lives outside the formal legal archive, in journalism and books and documentary film, and the accumulated commentary of decades, is not a fixed document. It continues to grow. New accounts are produced. Existing accounts are revised. Details are corrected and recirculated. The formal archive, by contrast, is not growing. It is fixed. The documents that were filed between 1975 and 1989 are the documents that exist. No new filing will be added to the Utah conviction record. No new entry will appear in the Colorado pretrial files. The Florida trial transcripts will not change. The execution log from Florida State Prison will remain exactly as it was written on the morning of January 24th, 1989. The particular quality of a closed legal record is a kind of stillness. The activity that produced the record, the investigations, the trials, the appeals, the years of institutional management, has ended, and what remains is the documentation of that activity, held in systems designed to preserve and to make accessible, but not to revise. The pages in the Utah Court Archive say what they say. The pages in the Colorado files say what they say. The transcripts from the Miami and Orlando courtrooms say what they say. The sentences Judge Cowart entered into the record in the summer of 1979 are there in the same form they were when he entered them. The formal language of a capital sentence, the date, the signature, the court's seal, the record of the case, distributed across the archival systems of 3 states, is one of the more extensively documented criminal legal histories in the American record. The volume of documentation, the tip sheets from 1974, the traffic stop report from Granger, the Duranch trial transcripts, the Colorado pretrial filings, the 2 escape investigation reports, the Florida arrest documents, the 2 trial transcripts from Miami and Orlando, the appellate filings, the execution records, is not unusual for a case that moved through as many jurisdictions and over as many years as this one did. What makes it particular is the number of formal decision points documented within it, the moments when the record shows a proceeding beginning, a verdict returned, a sentence entered, an appeal decided, and finally the last administrative entry made in a prison log on a January morning in Florida. That entry, 716A, January 24th, 1989, sits at the end of a chain of documentation that runs back to August 1975, when a highway patrol sergeant in Granger, Utah, swept his flashlight across the interior of a tan Volkswagen Beetle and found a crowbar, a pair of handcuffs, a ski mask, rope, and an ice pick laid out across the seats and floor. The chain between those 2 documents covers 13 and a half years of institutional activity, the work of courts, correctional facilities, investigative agencies, and appellate bodies in 3 states producing paper at every stage, filing it, archiving it, holding it in the systems designed for that purpose. The chain is complete. The links between those 2 documents, the 1975 traffic stop report and the 1989 execution log, are all present in the record. What rests in those archives now is quiet. The tip sheets from 1974 are in their folders in King County. The Daranch trial transcript is in its place in the Utah court system. The Garfield County Escape Investigation Report is in its file. The Pitkin County Security Review is in its file. The Miami trial transcript runs to many volumes and is held in the Dade County Court Archive. The Orlando trial transcript is in the Orange County system. The appellate record is distributed across the Florida courts and the relevant federal courts that heard the case. The execution log is in the Florida Department of Corrections archive, in Ryford, in a folder among other folders, on a shelf among other shelves, in a building that holds the administrative records of the state's correctional system. The questions that were still open in 1989, the cold cases in Washington, in Oregon, in Colorado, in Utah, in other states, whose connections to Bundy's name were noted but not always conclusively established, remain in their own files, in their own investigative systems, held by the agencies that have maintained them through the decades since. Some have been updated with findings from subsequent reviews.